Hello, welcome back. My name is Ned Williams, and this is part 5 of the Fixing Everything series, presenting my solutions for fixing government. In this video, we will deal with tort reform. It should be noted that court systems are state issue rather than federal. However, this solution for reducing the economic disruption caused by our current legal process is offered for your consideration, because a functioning system for dispute resolution is one of the key roles of government. I have no formal legal background, but if I did, it would be in my financial interest to maintain the current system. The current court system was created by lawyers through legislators to be monitored by lawyers, judges, for the benefit of lawyers, litigators. My proposal should encourage both reasonable positions and out-of-court settlements, thereby avoiding the entire court process with its gross misallocation of resources. Only a simple procedural change will be necessary to dramatically improve both process and outcomes. All of you have heard of outrageous court awards. In fact, there's even an annual publication called the Stella Award, listing the year's most shocking court cases. The award's name comes from the famous case of Stella Liebeck, a 79-year-old woman who suffered burns from hot coffee from McDonald's that she spilled in her lap. She was initially awarded $2.9 million. In a 2007 Stella Award, Judge Roy Pearson sued a mom-and-pop dry cleaner for $65 million for losing his pants. Actual cases and some urban legends heighten fears of being sued. Awards like these have led to misuse of our court system as a legal lottery. High legal fees encourage ambulance chasing and class action suits. And defendants are often forced to settle meritless cases to avoid the possibility of a catastrophic outcome and to avoid tying up top executives in legal action. But such meritless settlements have led to a flurry of additional meritless actions. In all but 8 states, American civil procedure follows what's called the American rule, under which each party pays their own legal fees. Under the British rule, also called loser pays, the loser pays court costs and the winner's legal fees. Loser pays is used by 8 states, but only for specific types of cases to encourage or discourage certain behaviors, including unfair or deceptive business practices, frivolous lawsuits, or pretrial offers of settlement. The prevailing American system has many flaws. The interests of the lawyers are often at odds with the litigants and society. Deep-pocket litigants sometimes game the system with threats of costly, drawn-out lawsuits. Legal advocates often engage in what's called anchoring. Anchoring is a process of taking an unrealistic initial position in order to frighten an opponent and to make later reduced demands sound more reasonable. Rogue juries frequently compensate victims based on emotion or empathy with the victim. The current system wastes valuable resources. There are too many lawyers. These are our best and brightest who could be utilized more productively elsewhere. Time is wasted for all of the participants: litigants, witnesses, court personnel, and jurists. The cost of liability insurance and avoidance procedures are passed through to the general public, making U.S. products and services more expensive. In 2008, court litigation in the United States was estimated to have cost small businesses $105 billion. My proposed solution will promote early settlement, reasonable positions, and it will bypass attorneys and courts whenever possible. My solution is called less reasonable pays, and it's a modification of loser pays. Under this system, potential outcomes will be known by the litigants early in the process. Probable trial outcomes become far less attractive than a negotiated settlement. And even if the case goes to trial, final results will be reasonable. Under less reasonable pays, the plaintiff must provide a final demand, and the defendant must provide a final offer at a pretrial litigation conference. While settlement between parties can be negotiated any time before trial or during the trial, final demand and offers presented at the pre-litigation conference cannot be changed for purposes of the trial itself. If a jury verdict is required, the jury must decide only two things. Is the defendant liable? And if he is liable, which final demand or offer is more reasonable? If defendant is liable and plaintiff's final demand is found to be more reasonable by the jury, then defendant must satisfy the plaintiff's final demand and pay both plaintiff's and his own legal fees plus court costs. If the defendant is not liable, plaintiff pays defendant's legal fees, court costs, and his own legal fees. Here we add an additional option to loser pays. If defendant is liable, but his final offer is found more reasonable, then defendant satisfies his final offer to plaintiff. However, plaintiff must pay all legal fees and court costs. Here's the rationale for this approach. Since both parties have a strong incentive to appear more reasonable to the jury, both demand and offer should be forced towards a compromise solution, making the jury's decision on reasonableness a 50-50 proposition. At the end of the pre-litigation process, both parties will know their counterparty's best offer. The probable outcome for each litigant is heavily weighted against going to trial. While later settlement is always an option, any marginal improvement in position may well be overshadowed by attorney's fees. Both litigants face a 50% probability that the trial result will be far worse than their pretrial offer or demand, so both should be highly motivated to settle, especially when considering the time and effort for the trial process. Here's an example. Let's assume that the actual loss is $40,000. Plaintiff demands $50,000 and defendant is offering $30,000. Legal fees are approximately $10,000 for each. The court costs are $5,000. If plaintiff is found more reasonable, defendant must pay $50,000 plus $25,000 in legal fees and court costs for a total of $75,000. If defendant is found more reasonable, plaintiff receives $30,000, but he pays $25,000 in legal fees and court costs for a net of only $5,000. Plaintiff wants $50,000 but might end up with only $5,000. Defendant is willing to pay $30,000 but might owe $75,000. Behavior economics predicts that non-gambler litigants will overweight the probability of a negative outcome. Defendant will fear the $75,000 outcome, and plaintiff will fear the $5,000 outcome. For both parties, settlement somewhere between $30,000 and $50,000 is far preferable. While our example deals with monetary settlements, doesn't it make sense to force parties to be reasonable in something like a child custody hearing? Using this new approach, very few lawsuits will go past the initial arbitration meeting, and those that do should have reasonable outcomes. Frivolous lawsuits and unmerited avoidance settlements will disappear. Liability, insurance, and litigation avoidance procedures will diminish, with reduced costs benefiting the general population. Private negotiations will increasingly be conducted in a spirit of compromise. To summarize, under less reasonable pays, litigants must establish final demand and offers at a pre-litigation conference. At the trial, the jury determines if liability exists and which litigant provided the more reasonable settlement offer. Even if defendant is found liable, it is the less reasonable litigant who pays all legal fees and court costs. Well, that's it for now. If you missed part 1 through 4 of the Fixing Everything series on MHTV, they can be found on YouTube by searching my full name, Nedland Williams, or by searching Fixing the Federal Government. Please pass these links on to your friends. Only a well-informed public can force litigators to fix our government. Thanks for watching. See you again soon.